Hello everyone, this is Crypto Law, and today we're going to do an analysis of this class action complaint wherein a plaintiff who was a holder of this crypto known as Ethereum Max ended up suing some pretty high profile individuals, Kim Kardashian, Floyd Mayweather, and Paul Pierce, and a few of the executives that are involved in the project, the Ethereum Max project. So I know that this was a pretty hot topic. It made a lot of headlines throughout the major news organizations, mainly because of the defendants that were named in this suit. They're pretty high profile, Kim Kardashian and Floyd Mayweather. And so I just kind of wanted to do an overview of what's going on with this case and go through the class action complaint. But before we do that, if you like this content, please hit the like button, subscribe to our channel. We'd really appreciate it, and follow us on Twitter. We are at CryptoBitLaw on Twitter. Thanks. So starting off here, we could see this is a copy of the complaint. It was filed in the United States District Court for the Central District of California. So we know that it's in federal court in the Central District of California. You can see a copy of this complaint linked in the description below. You can pull up the docket and follow along for yourself if you'd like to. So let's start here. This is the plaintiff, Ryan Heugerich. He's suing individually on behalf of himself and all others similarly situated. So let's figure out who this plaintiff is. So a basic Google search reveals this website, ryanheugerich.com. And if we go to that website, we could see on the About page, Heugerich refers to himself as a producer, series pitcher, and hustler based in New York City. And we can scroll down and see this is Heugerich right here, and here's another picture of him. So here's another part of his website that pertains to cryptocurrencies. I archived it in the Wayback Machine, so you could pull this up for yourself in case it goes down. And he claims that he is a proponent of blockchain, DeFi, and crypto. He claims to have a great deal of knowledge in the space, and he offers individualized consultations to help people learn, set up their wallets, so on and so forth. And he sells these for $50 for 60 minutes of a consultation. And you could check out this and see on his website, and then even book a consultation with him if you so desire to choose to do that. So going back to the complaint, we could see that the firm representing the plaintiff is Scott & Scott. In particular, the attorney that signed off on this complaint is John T. Jasnock. So here is Scott & Scott's website. We could see that their practice focuses on antitrust, securities litigation, consumer litigation, and corporate governance and shareholders' rights. Here is a bio of the attorney that signed off on this complaint, Jasnock. Now, what's interesting is I ended up going into a Twitter space with a few of the Ethereum Max community members to do some research for this project, and they informed me that this law firm, Scott & Scott, was actually trolling for plaintiffs in some advertisements that they found, and then sent me some of the screenshots that they took from some Facebook ads. And so you could see them here. This is what I was provided with. It's advertisement information from Scott & Scott, view ads here, information about the advertisement. Here's the ID number, and they are trolling for plaintiffs that were involved in Ethereum Max. And they were planning a Ethereum Max class action, as we can see here, and pretty much laying out their whole theory of the case. And so this is the first set of screenshots. You can take a look at them. So here are some more of the screenshots from the law firm that is representing the plaintiff in this case, seeking out plaintiffs for this litigation, requesting a full name, email, phone number, terms and condition, privacy policy, letting the potential plaintiffs know that there's no cost to them. Just some more about the advertisement seeking out plaintiffs for this case. Some registrant information for Scott & Scott. It's registered to Daryl Scott, their address, so on and so forth. And they launched this campaign in September of 2021, as we can see here in this screenshot. And then recently, earlier this month, this lawsuit was finally filed. So they were actually seeking to gather everything that they needed in order to file this lawsuit well before it was even filed. So I think that those screenshots were pretty revealing. It could kind of give you a sense of the motivations behind this lawsuit and really who the core players are here, why it was filed. You could see that there's this law firm that pretty much specializes in class actions like this. So it would lead one to believe that there is the motivation to file it in order to try to get class action status and then manage the class as the attorneys and then reap all of those fees that you would get. Or before you even get to the point of getting a class certified, you could eke out a settlement and then get a proportion of the settlement. So, and this is a pretty common practice in the legal world. Law firms that specialize in certain practice areas pretty much dictating the course and almost forcing and creating litigation through their own volition. So turning back to the complaint, we could see that the defendants listed here are Steve Gentile, Giovanni Perrone, Justin French, and they are executives and some of the leaders of the Ethereum Max project. And then we can go to the big names here, the high-profile defendants, Kim Kardashian, Floyd Mayweather, Paul Pierce, and then they listed Defendant X and John Doe's 1 through 10. And if you're familiar with some of our previous videos where we've done similar things and analyzed these complaints, the reason for listing a John Doe is in a situation where a plaintiff wants to name defendants, but they don't have all of the information available to them at the time of filing the complaint that would enable them to properly name all of the defendants that were involved. They would list a defendant as a John Doe, and then once they gain more information about the identity of that particular defendant, they can go back and then amend the complaint to then properly name the defendant whose identity was revealed through discovery, and then properly name that defendant in the amended complaint as filed later. So I guess one of the examples of this, as I mentioned before, is situations like those Napster file sharing cases. Imagine you are a record company and you're trying to sue someone for file sharing and you don't know who they are. You would file a lawsuit against John Doe, and then once you get discovery in the case, you can file a subpoena on the internet service provider where you take the IP address that you have that's alleged to have illegally shared the file, bring that to the ISP, and then say, hey, ISP, who is the person, the named person that is linked to this IP address? And then once you have the name of that person, you can then go back and amend the lawsuit and properly name that defendant. Continuing on, we could see that this is a class action complaint, and the plaintiff is demanding a jury trial. So this first paragraph gives a nice little overview of the suit. It states, Plaintiff Ryan Heugerich, the plaintiff, individually on behalf of all others similarly situated, brings this class action complaint against defendant Ethereum Max, referred to as the company, Steve Gentile, Giovanni Perrone, Justin French, collectively the executive defendants, Kimberly Kardashian, Floyd Mayweather Jr., and Paul Pierce, known as the promoter defendants, and together with the executive defendants, they will all be known as the defendants. The following allegations are based upon personal knowledge as to plaintiff's own facts, upon investigation by plaintiff's counsel, and upon information and belief where facts are solely in possession of defendants. So now we move along to the next section of the complaint where it lays out the nature of the case, and it begins that the plaintiff brings this action on behalf of all investors who purchased Ethereum Max tokens, EMAX tokens, between May 14th, 2021 and June 27th, 2021 and were damaged. Continues that this case arises from a scheme among various individuals in the cryptocurrency sector to misleadingly promote and sell the digital asset associated with Ethereum Max to unsuspecting investors. The company's executives, collaborating with several celebrity promoters, A, made false or misleading statements to investors about Ethereum Max through social media advertisements and other promotional activities, and B, disguised their control over Ethereum Max and a significant percent of the EMAX tokens that were available for public trading during the relevant period, known as the float. The third paragraph continues, in furtherance of this scheme, defendants touted the prospects of the company and the ability for investors to make significant returns due to the favorable tokenomics of EMAX tokens. In truth, defendants marketed the EMAX tokens to investors so that they could sell their portion of the float for a profit. It continues, defendants' strategy was a success. The misleading promotions and celebrity endorsements were able to artificially increase the interest in and price of the EMAX tokens during the relevant period, causing investors to purchase these losing investments at inflated prices. In addition, the executive defendants disguised their control of Ethereum Max to avoid scrutiny and facilitate this scheme. The executive defendants then conspired with the promoter defendants to sell their EMAX tokens to investors for a profit. And it continues, plaintiff brings this class action on behalf of themselves and an objectively identifiable class consisting of all investors that purchase EMAX tokens between May 14th and June 17th, 2021. So pretty much what they are alleging here in this complaint is a pump and dump, a collusion between the executives of EMAX and the celebrity promoters that was improperly disclosed or not even disclosed and ultimately pumped and then dumped. So the general theory is that a lot of these insiders have control of a large portion of these tokens, and then they'll go out and promote it and then pump the price through their promotion and gain interest and engagement through the promotion of those tokens. And then once it's starting to get viral and people are starting to notice it and the buying pressure's on, the price goes up. And then once the price goes up, they start dumping and selling their tokens at the higher price, pretty much creating sell pressure in the market, resulting in the price of the tokens going down. So the people that would be harmed in this theory are the retail investors that came along after the fact and pretty much bought the top and then bought into all of the hype, because they're buying these tokens at an inflated price that ultimately dumped in value after the insiders pretty much unloaded their bags on all of these retail investors. So the complaint continues and it goes on to the next section, which outlines the parties. And it begins with the plaintiff, Ryan Heugerich. We already did a brief overview of him. It states that he's a resident and citizen of New York and lives in Brooklyn, and that he purchased EMAX token and suffered an investment loss as a result of the defendant's conduct. And then it moves on to the defendant, Stephen Gentile. It states that he's a resident and citizen of Connecticut. It claims that he's the co-founder, creator of Ethereum Max and exercised control over Ethereum Max and directed and authorized or indirectly authorized the sale and or solicitation of EMAX tokens to the public. It does pretty much the same thing for Giovanni Perrone, except that it states that he's a resident and citizen of Florida. Same thing for Justin French, except that he is a resident of South Carolina. And then we move on to Kim Kardashian, the heavy hitters, the big influencers. It states that Kim Kardashian, she's a resident citizen of California, and that Kardashian acted as a promoter for Ethereum Max and EMAX tokens. It moves along to Floyd Mayweather. It states that he's a resident citizen of Nevada, and that he acted as a promoter for Ethereum Max. It moves on to Paul Pierce. He's a resident of California and acted as a promoter for Ethereum Max. And then we move on to Corporate Defendant X. So for Corporate Defendant X, it states that Corporate Defendant X is the corporate entity behind Ethereum Max and the EMAX tokens who participated in the wrongdoing alleged herein, but whose identity is currently unknown to the plaintiff. plaintiff will identify the appropriate corporate defendant through discovery of the executive defendants. So they're pretty much claiming that there is a corporate like business entity, whether it's an LLC or a corporation, that actually acts as Ethereum Max, whether it is a business that serves as a corporate veil for the executive defendants. We don't know at this point, but the plaintiff believes that there is a corporate entity that serves as a figurehead or a cornerstone of Ethereum Max, and they don't know who it is yet or what the business entity is, and that they will discover it through discovery and then amend the complaint to add them after the fact. And then finally it concludes with the defendants John Doe's 1 through 10, and it states that they participated in the wrongdoing alleged herein and their identities are currently unknown to the plaintiff, and that they will add them as a result of discovery. So next we move on to the section pertaining to jurisdiction and venue, and this is pretty technical section that has to deal with the civil procedure of actually getting this case into court and establishing that this particular court has jurisdiction over this case, subject matter, and the parties at issue, and you have to follow certain procedural rules when you file a complaint and then ultimately see it out through the litigation process. Now, we have gone over an analysis of the various requirements for a lawsuit as it pertains to jurisdiction and venue in some of our previous videos. If you want to learn more about that, check out our video on the Hex class action analysis. So following that, we move on to the section that pertains to factual allegations of this matter, and it starts by giving a background on Ethereum Max. Now, before we go over what the complaint alleges with regards to what Ethereum Max is, I just wanted to pull up the white paper for Ethereum Max, pulled from the project's website. It's going to be linked down in the description below. And there is a section where it gives an overview of what is Ethereum Max, and it states, Ethereum Max is a progressive ERC20 token built on the secure Ethereum network. We launched EMAX with a vision to bridge the gap between the emergence of community-driven tokens and the well-known foundational coins of crypto, creating a unique token that provides lifestyle perks with financial rewards and incentives to its holders with a pathway for practical, long-term use in everyday life. This is the essence of the culture token. Now, if you dig deeper down to the white paper, it goes into further detail onto the actual aspects of this project. Apparently, there is a three-part token system where there is the community-driven token, EMAX, and then a DAO-based token, XMAX, and then an algorithmic stablecoin, MaxPay. And so, I mean, it's all pretty interesting, and you can learn more from the white paper that's linked down below. So returning to the complaint, it describes the EMAX token as a speculative digital token created by a mysterious group of cryptocurrency developers, including but not limited to the executive defendants. In particular, the EMAX tokens are blockchain-based digital assets known as ERC20 tokens that are created using the Ethereum blockchain. After an ERC20 token is created, it can be traded, spent, or otherwise transacted with. The EMAX tokens were primarily traded against Ether, the native currency of the Ethereum blockchain network, on Uniswap and other decentralized exchanges that allow anyone to list a token. On May 14, 2021, the executive defendants launched the EMAX tokens with a transaction volume of 16.11 million and a price of fractions of a cent, according to data from CoinMarketCap. At the time of the launch and throughout the relevant period, the EMAX tokens were not sold pursuant to white papers. White papers in cryptocurrency are documents released by the founders of the project that give investors technical information about its concept and a roadmap for how it plans to grow and succeed. And then there's a little footnote that states that Ethereum Max has no connection to the second largest cryptocurrency, Ethereum. They allege that the name association appears to be an effort by the company to mislead investors into believing that EMAX tokens were part of the Ethereum network, and then they make a rather humorous analogy that states it would be akin to marketing a restaurant as McDonald's Max when it had no affiliation with McDonald's other than the name similarity and the fact that both companies sell food products. The complaint continues that subsequently, however, the company did release a white paper in October 21 entitled Ethereum Max Disrupt History, which explained the business model for Ethereum Max and described its activities during the relevant period. According to the company, quote, "We launched Ethereum Max with a vision to bridge the gap between the emergence of community-driven tokens and the well-known foundations." Okay, we pretty much read over that in the white paper that we read through. It continues, "The founders' approach to bridging this gap was to simplify the complex and instill confidence through a trusted circle that can provide guidance and instill trust." And then it states, "In plain terms, Ethereum Max's entire business model relies on using constant marketing and promotional activities, often from, quote, trusted celebrities, to dupe potential investors into trusting the financial opportunities available with EMAX token." The white paper was reviewed by ICO Law PC, a law firm located in Los Angeles. The complaint further states that the company later even bragged in its white paper that its, quote, expertise in marketing strategy and managing relationships was a key area for Ethereum Max's successful promotional efforts in the preceding 6 months. In other words, the relevant period. The complaint cites the following statement: "Each week, we track and analyze our marketing efforts, continuing to make strategic modifications to optimize engagement for week-over-week improvements and impact. If we can do all of this in less than 6 months, imagine what the future holds. The best is yet to come." So in this next section, the complaint gets to the more juicy set of factual allegations. They title it "The Pump. Promoter Defendants Shill Ethereum Max." And it begins, "As the subsequently released white paper acknowledged, the executive defendants actively recruited and retained the promoter defendants to serve as the promoters for the launch of the EMAX tokens in May 2021. Upon information and belief, the promoter defendants received EMAX tokens and/or other forms of consideration as part or all of their compensation for promoting Ethereum Max. The promoter defendants are sophisticated public figures with familiarity and experience with endorsement contracts. On May 26, 2021, former NBA player and television personality defendant Paul Pierce promoted Ethereum Max in a widely discussed post on the social media platform Twitter during an online dispute between defendant Pierce and the television broadcasting network ESPN. Prior to the May 26 post, defendant Pierce had worked for ESPN as a sports analyst and commentator until he was fired for an unrelated video he had previously posted to his social media account. After his firing, defendant Pierce publicly slammed ESPN while conversely praising Ethereum Max's ability to make money for him at the same time. So here is a screenshot of the tweet at issue where it's Paul Pierce and he is tagging ESPN stating that, "I don't need you, I got Ethereum Max. I made more money with this crypto in the past month than I did with y'all in a year. Truth shall set you free." Googly face emoji, my own boss, ethereummax.org. Check it out for yourself, and a link to the website, Ethereum Max. It continues, "That same day, Ethereum Max issued a press release announcing that it was now the exclusive cryptocurrency accepted for online ticket purchasing for the highly anticipated Floyd Mayweather vs. Logan Paul pay-per-view event, June 6, 2021, in Miami Gardens, Florida. The press release directed investors seeking more information to visit the company's social media accounts and the FIGHT website, the following hyperlink, mayweatherpaultickets.com. The FIGHT website featured defendant Mayweather and offered various incentives for those purchasing online tickets with EMAX tokens, including, quote, orders over $5,000 will receive authentic signed Floyd Mayweather boxing gloves, 2 front row ringside tickets available exclusively for Ethereum Max purchase, and all Ethereum Max purchases will receive 10% discount at checkout." And it continues, "Tickets purchased with Ethereum Max automatically entered into a lottery drawing to attend the official Mayweather after party at a private table at LIV," which I'm assuming is a club. Continuing on, it states that the trading volume for EMAX tokens exploded as a result of defendant Pierce's post and the company's announcement that it was partnering with defendant Mayweather. On May 26, 2021, the volume reached 44.43 million, almost 5 times higher than the previous day. Then, on May 27th, the volume more than doubled, reaching 107.7 million. On May 28, 2021, Ethereum Max released a similar press release entitled Ethereum Max Disrupts Miami Ahead of Mayweather vs. Paul Fight as the first cryptocurrency of major nightclubs LIV and Story. The press release came out of Los Angeles and highlighted the previous Mayweather vs. Paul release and quoted Defendant Pierce's tweet verbatim. On June 4, 2021, former world champion boxer Defendant Floyd Mayweather Jr. attended the Bitcoin 2021 conference in Miami. While there, instead of discussing the cryptocurrency that was the focus of the conference, in other words, Bitcoin, Defendant Mayweather promoted Ethereum Max. In particular, Defendant Mayweather and his entourage wore t-shirts with the Ethereum Max emblazoned across their chest. At the same time, Defendant Mayweather, continue on, proclaimed during a panel discussion, "I believe there's going to be another cryptocurrency just as large as Bitcoin someday." Okay. 2 days later, on June 6, 2021, Defendant Mayweather similarly promoted Ethereum Max during his highly viewed exhibition boxing match with internet celebrity turned boxer Logan Paul. Between June 4, 2021 and June 6, 2021, the trading volume for EMAX tokens spiked from 15.7 million to 24.5 million. On June 8, 2021, executive defendants Gentile and Perrone, along with Josh James, the lead developer of Ethereum Max, uploaded a video of themselves on YouTube entitled, quote, "Addressing the EMAX Community, Ethereum Max." Defendants Gentile and Perrone identified themselves as the creators of Ethereum Max and explained that Mr. James had recently joined Ethereum Max as its new lead developer. Defendant Perrone described his prior experience in the, quote, the hedge fund space and had, quote, significant experience structuring nuanced securitizations and financing arrangements, and he touted Ethereum Max as something special with real sustainability, while Defendant Perrone also stated that they were able to forge a landmark agreement with the Mayweather team and reassured investors regarding the volatility in the EMAX token. Continuing on, Defendant Gentile further stated that Ethereum Max's work with launching ambassadorships and working with influencers was not solely in preparation for the Mayweather fight, but rather the launch point with great prospects moving forward. Defendant Gentile also noted that his background involved specialties revolved around marketing and brand development, and he exclaimed that Ethereum Max was a super exciting project and that he was excited for the updates and would be rolling out in the near future. Defendant Gentile claimed that it was, quote, going to be beneficial not only to the token, but more importantly, the community. The next paragraph states that during a pseudo question and answer portion of the video, Defendant Gentile brought up investors' questions about a, quote, rug pull of the EMAX token and asked Defendant Perrone to nip it in the bud. Defendant Perrone stressed that the Ethereum Max team was in for the long term, stating, among other things, that the executive defendants were looking to lock the wallets to show investors that they were here to stay. On June 14, 2021, reality television personality Defendant Kim Kardashian posted the following solicitation for Ethereum Max on her Instagram account, which has over 250 million followers. And the complaint has a screenshot of the post from Instagram by Kim Kardashian. You could see it right here. As noted in the scathing op-ed piece called "Celebrity Crypto Shilling is a Moral Disaster," Kim Kardashian's post was an immediate sensation and a touch controversial. The EMAX token was only a month old, few had heard of it, and it wasn't even obvious how the token was supposed to work. More than that, Kardashian was urging her 251 million Instagram followers to get involved in a highly volatile speculative market that's little different than gambling in the world's most fraudulent casino. It states, Defendant Kardashian's promotion had tremendous reach. The financial services company Morning Consult analyzed the impact of celebrities on crypto investor decisions, and in particular the impact of Defendant Kardashian's Ethereum Max post. The survey found that up to 21% of all American adults and nearly half of all cryptocurrency owners had seen this ad for a risky financial instrument. Furthermore, Defendant Kardashian's conversion was also impressive. A striking 19% of respondents who said they had heard about the post invested in Ethereum Max as a result. Well, that's pretty shocking, big if true. I mean, that's a pretty engaging post, so to say. It continues, the chair of the Financial Conduct Authority, the FCA in the United Kingdom, Charles Randall, in a September 6, 2021 speech given at the Cambridge International Symposium on Economic Crime, remarked that Defendant Kardashian's Ethereum Max post was the financial promotion with the single biggest audience reach in history. Notably, Defendant Kardashian's post did include a promotional disclosure in the post itself. However, this disclosure is tucked in the far bottom right of the post and is just 3 characters long. Hashtag AD. While it's unclear what the precise terms of the financial compensation that Defendant Kardashian was given by the executive defendants, Defendant Kardashian routinely gets paid between $300,000 and $1 million for most promotional posts. Defendant Kardashian even stated that she makes more money off these promotions than an entire season of a reality TV show. Defendant Kardashian also has experience and familiarity with making misleading claims in similar promotional endorsements on her Instagram and Twitter accounts. For example, in 2015, the United States Food and Drug Administration ordered Defendant Kardashian to remove a promotional post she had made with a strikingly similar beginning to the EMAX post at issue in this action. And then they include a screenshot of that particular post that we could read from it. OMG, have you heard about this? As you guys know, my morning sickness has been pretty bad. I tried, and then a link to the Shield product. Interesting. Continuing on, Defendant Pierce did not include any promotional disclosure when he tweeted about Ethereum Max on May 26, 2021. It does not appear that Defendant Mayweather has disclosed any payments either for his promotion of Ethereum Max on June 4th and 6th. Defendant Mayweather does have experience with being fined previously over improper cryptocurrency promotion, and as a result, he knew or should have known that his conduct alleged herein was improper. And I think that that line is telling. They included that likely to meet a legal standard where, there's certain laws where if you're found to be in violation of the law, you either knew or should have known that the conduct that you engaged in was improper. And so I think that that's probably the main reason why they included that legal term of art. So this next paragraph gives an overview of Mayweather's previous conduct with not properly disclosing his promotion of a crypto. And it states that in November of 2018, Mayweather and another celebrity promoter settled charges with the U.S. Securities and Exchange Commission for failing to disclose payments they received for promoting fraudulent cryptocurrency investments. One of the posts at issue, there was one that Defendant Mayweather made on Twitter stating, "You can call me Floyd Crypto Mayweather from now on," and a promotion with the message to his Twitter followers that a company's fraudulent initial coin offering, quote, "starts in a few hours. Get yours before they sell out. I got mine." As part of the settlement, Defendant Mayweather agreed to pay $300,000 in disgorgement and $300,000 penalty and $14,775 in prejudgment interest. In addition, Defendant Mayweather agreed not to promote any securities, digital or otherwise, for 3 years. The settlement was dated November 29, 2018, meaning that this agreement was blatantly violated in connection with Defendant Mayweather's Ethereum Max promotion. Defendant Mayweather, therefore, had an understanding that his own conduct, as well as the conduct of executive defendants, was improper and fraudulent. So now we move on to the next section of this complaint, and it is titled The Dump. EMAX token price plummets. And it begins, following the EMAX token's launch and defendants' promotional activities in May 2021, the trading volume and the price of Ethereum Max surged. By May 30th, EMAX already had a transaction volume of over 100 million, up 632% in just 2 weeks. The day before, it reached its maximum price of, we'll just call it 863, which represents a rise of 1,370%, more than its initial price of, we'll call it 5875. However, the meteoric rise did not last long, and Ethereum Max began to deflate immediately after Defendant Kardashian's post. On July 15th, the price of EMAX tokens hit an all-time low of, we'll call it 17 per unit, a 98% drop, from which it has not been able to recover. On August 1st, its transaction volume plummeted to 157,423, which is less than a hundredth of its initial capital. The promoter defendants' improper promotional activities generated the trading volume needed for all the defendants to offload their EMAX tokens onto unsuspecting investors. I guess they're pretty much claiming that they made these retail investors their exit liquidity. While plaintiff and class members were buying the inappropriately promoted EMAX tokens, defendants were able to and did sell their EMAX tokens during the relevant period for substantial profits. According to Defendant Perrone, the executive defendants did not lock their EMAX tokens wallets address until after the relevant period. The EMAX token price still has not recovered from the trading volume, and the trading volume remains down significantly. As bluntly noted in McKinnon's op-ed, if you bought Ethereum Max after Kardashian pushed it and didn't sell fast enough, all you were left with was practically a worthless digital asset, i.e. you were left holding the bag. So this next section, entitled Regulators Raise Concerns That Ethereum Max is a Pump and Dump Scam, pretty much gives an overview of this United Kingdom FCA chairman, his opinions on what happened with Ethereum Max and how social media influencers routinely promote certain cryptos based off of speculation, and then it generates FOMO, and then once there's this giant sell pressure, the price bottoms out, and then these retail investors are left holding the bag. So I'm not going to read over every part of this. You can check it out for yourself in the complaint, but that's pretty much what this section does. So this next section, entitled Class Allegations, pretty much sets forth all of the rules of civil procedure necessary to certify a class, and states allegations that, based on the facts of this particular case, this complaint complies with all of the requirements in order to certify a class. Things like numerosity. The class is so numerous that joinder of all members of the class is impracticable. Commonality. There are common questions of law and fact that exist to each member of the class. Typicality. The class members have the same interest as the plaintiff. Adequacy. Superiority. That a class action is a superior means of fair and efficient adjudication. It pretty much sets forth all of the legal, the actual law, and all of the allegations necessary to try to certify a class. So this next section is entitled California Law Applies to the Entire Class, and pretty much states that California's substantive laws apply to every member of the class regardless of where in the United States the class members reside. It continues that California's substantive laws may be constitutionally applied to the claims of the plaintiff and the entire class under the Due Process Clause, 14th Amendment, Full Faith and Credit Clause, so on and so forth, and that there were significant contacts to the claims asserted by the plaintiff and all class members, creating an interest that ensure that the choice of California state law is not arbitrary or unfair. So they're trying to pretty much lump this entire class under California state law, which, I mean, it's not really surprising because California has pretty liberal laws when it comes to, I guess, fraud and, some of these more business-centric types of law. So the plaintiff tries to bolster its choice to use California law by stating that Ethereum Max's decision to reside in California and avail itself of California's laws and to engage in the challenged conduct from and emanating out of California renders the application of California law to the claims herein constitutionally permissible. California is also the state from which the executive defendants' alleged misconduct emanated. The application of California laws to the class is also appropriate under California's choice of law rules because California has significant contacts to the claims of plaintiff and the proposed class, and California has a greater interest in applying its laws here than any other interested state. So now we move on to the part of the complaint where the plaintiff alleges his various causes of action. And the first cause of action, as we can see here, is a violation of the California unfair competition law, and then it states the actual site to where the law can be found, statutory law, California Business and Professional Code, section 17200, and this is alleged against all defendants. So we can see here that the plaintiff cites the law and quotes it and states that this particular law, the Unfair Competition Law, or UCL as they refer to it, prohibits any unlawful, unfair, or fraudulent business act or practice and unfair, deceptive, untrue, or misleading advertisement. So the plaintiff is alleging that the defendants violated this particular law and that courts have interpreted the UCL using different tests, including one, whether the public policy, which is a predicate to a consumer unfair competition action under the unfair prong of the UCL, is tethered to a specific constitutional, statutory, or regulatory provisions. Two, whether the gravity of the harm to the consumer caused by the challenged business practice outweighs the utility of the defendant's conduct. And three, whether the consumer injury is substantial, not outweighed by any countervailing benefits to consumers or competition, and is an injury that consumers themselves could not reasonably have avoided. And it's claiming that the defendant's conduct is unfair under each of those different tests. So then it continues that as a direct and proximate result of the defendant's unlawful, unfair, and deceptive practices, the plaintiff and class members suffered damages. The executive defendant's activities with the promoter defendants caused plaintiff and the class members to purchase and or hold the EMAX tokens when they otherwise would not have done so. So that brings us to our second cause of action, which is a violation of the California Consumers Legal Remedies Act, California Code of Civil Procedure, Section 1770, and this is alleged against all defendants. So the plaintiff cites this particular law, which prohibits the unfair or deceptive acts or practices undertaken by any person in a transaction intended to result or that results in the sale or lease of goods or services to any consumer, including but not limited to misrepresenting the affiliation, connection, or association with or certification by another and representing that goods or services have sponsorship, approval, characteristics, ingredients, uses, benefits, or quantities that they do not have, or that a person has a sponsorship, approval, status, affiliation, or connection that the person does not have. So then it continues and states that the defendants engaged in acts and practices that were deceptive for the following reasons: that they knowingly and intentionally concealed the executive defendant's specific roles and ownership interest in Ethereum Max, and knowingly and intentionally failed to disclose the use of promoter defendants to instill trust in uninformed investors to promote the financial benefits of a highly speculative investment in EMAX tokens in an effort to manipulate and artificially inflate the price and trading volume of EMAX tokens and allow defendants to sell their EMAX tokens at those inflated prices. So then it continues and states that the plaintiff and class members suffered damages as a result of the defendant's unlawful, unfair, and deceptive practices. And the plaintiff seeks punitive damages under this particular law. And they filed an affidavit stating facts showing that the action has been commenced in a county described in this section as a proper place for the trial of this action in compliance with this particular law. So this brings us to the third cause of action, which is aiding and abetting based on California common law, and this is against the promoter defendants. So this section states that under California law, aiding and abetting requires not agreement but simply assistance. The elements of aiding and abetting liability have cited the elements of the tort as they are set forth in the Restatement Second of Torts. Under California law, liability may be imposed on one who aids and abets the commission of an intentional tort if the person A. knows the other's conduct constitutes a breach of duty and gives substantial assistance or encouragement to the other to so act, or B. gives substantial assistance to the other in accomplishing a tortious result and the person's own conduct separately considered constitutes a breach of duty to the third person. Unlike a conspirator, an aider and abetter does not adopt as his or her own the tort of the primary violator. Rather, the act of aiding and abetting is distinct from the primary violation. Liability attaches because the aider and abetter behaves in a manner that enables the primary violator to commit the underlying tort. Okay, so for the uninitiated, a tort is pretty much a wrongdoing, a wrongful act. In the realm of tort law, there are intentional torts, something that you intentionally do, to someone else, like conversion, that's pretty much civil law theft, or battery, that is a harmful or offensive contact with another person. And then there are unintentional torts, where an unintentional tort is pretty much negligence. So then it continues and tries to link the defendant's actions with this law and the violation of the law. And it states that the promoter defendants have previous knowledge and experience with making misleading promotional statements. And then it cites Mayweather's previous misconduct, his prior fines. And then it states that as a result, they knew or should have known that the marketing strategy employed by the executive defendants for EMAX tokens was unlawful and violated this particular law. And it continues that the promoter defendants provided assistance that was a substantial factor causing the EMAX token price to both surge and do so long enough for the defendants to sell their EMAX tokens for huge profits at the expense of their followers and investors. Without the help of the promoter defendants' activities, the executive defendants would have been unable to use the misleading marketing strategy devised by defendant Gentile, and defendants would not have been able to commit the violations of the California state consumer protection statutes alleged herein. And as a direct and proximate result of the promoter defendants' unlawful, unfair, and deceptive practices, plaintiff and class members suffered damages. So pretty much what they're saying, it's, but for the promoter defendants' assistance in those promotions of the EMAX tokens, the executive defendants would not have been able to devise this grand scheme that they're alleging and pump and dump the EMAX tokens on the... So this brings us to our fourth and final cause of action, which is unjust enrichment / restitution. And it's California common law in the alternative, and it's alleged against all defendants. So this section states that the plaintiff and the members of the class conferred a monetary benefit on the defendants by raising the price and trading volume of the EMAX tokens, which allowed the defendants to sell their EMAX tokens to the plaintiff and class members at inappropriate and artificially inflated prices. Defendants received a financial benefit from the sale of their EMAX tokens at inflated prices and are in the possession of this monetary value that was intended to be used for the benefit of and rightfully belongs to the plaintiff and the members of the class. Plaintiff seeks restitution in the form of monetary value of the difference between the purchase price of the EMAX tokens and the price those EMAX tokens were sold for. So that's just general unjust enrichment. You got a benefit, but you didn't really deserve it because of your fraudulent or deceptive activity. And this moves us to the last portion of the lawsuit, the prayer for relief and the jury demand. And this is pretty much what the plaintiff is asking the court to do for him. And he wants a determination that the claims alleged herein be maintained as a class. So he wants the court to certify a class in order to move forward as a class action. He wants to be appointed as a representative of the class, and he wants his lawyers to be the counsel of the class. He wants an award, general, special, incidental, statutory, punitive, and consequential damages and restitution for himself and the class, post-judgment interest, injunctive or declaratory relief, so in order from the court pretty much prohibiting the defendants from doing something or to stop doing something. He wants attorney's fees and costs, and the catch-all, such further relief that this court deems appropriate. And then he wants a jury trial, as seen by the jury demand. And then it was signed, and it was filed on January 7th of 2022. So with all that said, I think that this case is pretty interesting. I guess based on what we have here, I really highly doubt that this case ends up going to trial. I think what will ultimately happen is that the defendants will probably obtain some sort of settlement, based on, my opinion and some of the opinions bouncing around on crypto Twitter or whatnot. One of the main reasons why this lawsuit was filed was, I guess, in part due to the notoriety that was gained for the law firm and the plaintiff in actually filing this thing. Their names were plastered everywhere in a lot of the mainstream media organizations that covered this particular story. So there was that motivation. And then ultimately, if the plaintiff and his lawyers can eke out some sort of settlement, then they'll get all of the fees and the monetary compensation that results from that settlement. So ultimately, what we have here is it's going to be a long, drawn out battle of attrition on both sides. The litigation process is very long, very arduous. It's almost like it's a game of leverage. How much leverage can you get over your opponent in order to either A, put them in their place at trial, or B, leading up to the trial, get them in a situation where it would behoove them to settle rather than actually having to go to trial or continue airing all of this dirty laundry or whatnot. It would be really interesting to see how this plays out if we actually get to the point of discovery. I'd like to see whether or not the defendants, the promoter defendants that were named, like Kardashian, Pierce, and Mayweather, whether or not they actually have Ethereum Max wallets. And if they do, I'd like to see the on-chain analysis tracking their transactions to see if they were actually involved in receiving tokens for their promotion of the product, and then at what time, if they did receive tokens, when they actually sold and dumped those tokens, and if it matches up with the timeline that was alleged in this suit. So that would be interesting. All right, so now we get to some of the more interesting aspects of this case. And I'd like to remind you before we continue that none of this is legal or financial advice. None of this information is an endorsement of anything presented here. I'm just reporting on things that I have found and discovered while researching these issues. And as you can see here, this is a tweet that I discovered by @MrBryGuy, and this is in reference to the plaintiff in this case, Ryan Heugerich. It's claiming that he bought on May 24th, weeks before celebrity endorsements. He had 12.5 billion tokens. Wait, his $2,000 buy turned into $12,000, and he didn't sell at the peak, so why is he suing? Supposedly a crypto guru. And as you recall from the analysis earlier on the plaintiff's website, he proclaimed to be some sort of crypto educator or consultant with expertise in crypto. And so if this is actually the case, if these actually are his on-chain trades, then this would cause some sort of an issue for the plaintiff as they attempt to proceed through this case. It would call into question some of the veracity of the claims stated within the complaint that we just reviewed. And if it turns out that this is actually the case, and this could all be verified in discovery if the defendants get access to the plaintiff's on-chain data, and they discover that these are in fact his trades, or his trades and buys into Ethereum Max don't match up with the timeline that was presented in the facts in that complaint, that could cause some sort of problems for the plaintiff going forward. Now, also, I'd like to remind you that this isn't an endorsement of this. I haven't actually tested the veracity of these claims because I don't have access to the actual addresses, but if what this guy is saying is true, then, as I said, that could be an issue going forward for the plaintiff. So now I'd like to turn your attention to some exchanges that I had with some of the community members from the Ethereum Max community while I was researching this project. This one member in particular claimed that the executives listed in the complaint weren't the original founders of this project, and in fact they were these individuals known as Justin Mayer, Jeremy Davis, David Miller, Matt Sinicola, Nick Ferris, Chris Peterson, Mario Perrone, James Seminella, Russ Davis, and the 10th, who's a dev from Nigeria or the UK, a pure scam artist, goes by the name of Elmo/Diamond Hands. And I'm not saying that these are facts. This is just what is reported to me that I am reporting to you based on the information that I garnered regarding this case. So this isn't an endorsement of any of this. This is just me reporting information that I observed. So he also continued with some information regarding the original contracts transaction, how it played out, an address linked to that guy Diamond Hands we were just talking about, the initial developer being Diamond Hands, airdrops. You could check out this message. And then we turn to this screenshot, which this individual claimed apparently they have a research group where they compiled all this information and they shared it with me. And he stated, the individual that shared these with me claimed that Justin Mayer posted this to clear his name, but he posted a bunch of screenshots, but must have missed this, or must have missed that he said this, LOL. And so as we're digging through here, we could see that there's a response in this group's text that, so we pay off Geo's guy and make a down payment to Russ. Mario, confirm you have 343. Get new investors in and start unwinding our positions. Are there any big payments on the horizon, more Floyd exchanges, etc.? So I don't know about the veracity of any of this. I'm just reporting what was told to me. So, I mean, in order to verify this, you would need subpoenas on cell phone providers and cell phone records, all of which I don't have because I don't have standing in the case. I'm just relaying to you, which was relayed to me based on my, research and diving in, trying to report on this issue. And then continuing along, you can see this one right here. This individual stated that Gio Perrone and Steve Gentile took over and tried to save the project. And beyond that, he also shared this screenshot where the way he explained it is that here's Justin Mayer admitting that him, Russ Davis, and Russ Davis's moderators own the coins that can drain liquidity. So this is interesting. And then moving on to the next one, this individual claimed that Russ Davis, Justin Mayer have tons of wallets in every project they launch as well. EMAX isn't the only one where they do this nonsense stuff. They've done it to many others, Peeps, Bezo, Jacend, Acel, Shuna, V1, and V2, a ton. And so the same individual that shared the other screenshots and correspondences with me also drew my attention to this Reddit post that pretty much goes over the same things that were discussed about this Defiant Crypto platform group on Telegram and Discord that's behind a lot of these ERC20 projects with the same names that he drew my attention to. So this is also linked down below in the description. Here's one other tidbit that was shared with me. It states that Gio and Steve caught them, those individuals that were mentioned earlier, that were part of that group that was mentioned in that Reddit post. He caught them and kicked them from the team, forked the project, and ever since have been spending a fortune trying to fix the project. Rush and Justin are mad they got caught and exposed, so they went to try to sabotage further. Gio and Steve bought out $2 million worth of these old founders coins over the last 2 months. A ton of voice AMAs in this group from Gio and Steve G. And here's a link with a Telegram group for Ethereum Max, and apparently some voice messages that are in this Telegram group. So with all that said, I think that there's a lot of interesting issues in this case and a lot that has yet to be revealed, and ultimately that's why the court system is there, in order to hash out fact from fiction and reveal as much of the truth as possible during the discovery process. I'd like to see what actually ends up coming out during the discovery, as we can get a better handle on the merits of this case and see how it all shapes up once everything's out there in the open. So again, I'd like to remind you guys that none of this is legal or financial advice. I am not vouching for the veracity of any of this information. I am just reporting it as it was presented to me, whether it be information that is claimed here in the complaint or information that was reported on the internet or reported to me by others. I'm just showing you guys what I have come across and then just kind of trying to give a handle on how the legal aspect of this works and trying to demystify some of the legal aspects of this. In terms of my opinion regarding how this will all end up shaping out, I believe that, as I said before, that there is a very slim chance that this case will ultimately go to trial because of the likelihood that there will be some sort of settlement as a result of the information that comes out in discovery. We don't know at this point if the plaintiff is entirely forthcoming. That's why we have discovery, in order to reveal whether or not there is whole truths involved in his allegations put forth in this complaint. And like any adversarial justice system, the defendants are entitled to their day in court. They're entitled to speak their piece and then put on their defense. So the complaint was framed in such a way that if they can eke out any sort of information that connects these defendants to this fact pattern in respect to the particular laws that were mentioned in violations of those laws, then the plaintiff would have a fair amount of leverage in ultimately either leveraging a settlement or forcing the defendant's hand at trial and getting a leg up with them if this case actually goes to trial, which I doubt it will. But I think it's interesting regardless, and it'll be interesting to see how this all plays out in time. So with that said, I hope you guys like this information. If you liked it, please hit the subscribe button, drop us a like, drop us a comment below, let us know what you think. Follow us on Twitter. We are at CryptoBitLaw, and we'll keep you updated on this case as it develops. And again, we hope you like this content, and we'll see you guys in the next video. Thanks for watching.